How did nolo contendere originate in legal history? Imagine being in court and wanting to avoid admitting guilt but still face the consequences. That's where the idea of a no-contest plea, or nolo contendere, comes from. It all started in English common law centuries ago. Back then, defendants could choose a plea that wasn't exactly an admission of guilt but still let the court impose penalties. They used it as a way to keep their reputation intact and avoid the stigma of a guilty plea. In early English courts, a defendant who entered a no-contest plea was not saying they were guilty but was not fighting the charges either. It was like a way to say, I accept the punishment, but I'm not admitting guilt. This was often seen as a plea for mercy from the king or sovereign. It was especially useful in cases where civil lawsuits could follow a criminal conviction. The no-contest plea was a common part of English legal procedures for many years. But by the early 1700s, it disappeared from English law. The courts decided it was too confusing or potentially unfair because it could be used to hide guilt. Still, the idea had already taken root elsewhere. When the United States formed its own legal system, it adopted the no-contest plea. It became part of federal and state courts, but with some rules. Courts had to approve it, and it could not be used in every case. Its main benefit is helping defendants avoid admitting guilt while still accepting punishment. This can be important if they want to avoid civil liability later. In criminal defense strategies, a no-contest plea can be a smart move. It's often part of a plea bargain, where the defendant agrees to plead no contest in exchange for a lighter sentence or other benefits. It helps protect their reputation and keeps their options open for future civil cases. So, the no-contest plea started as a way for defendants in English courts to avoid admitting guilt while still facing penalties. It traveled across the Atlantic and became a useful tool in American criminal justice. Its origins show how legal strategies can evolve over time to serve the needs of defendants and courts alike.